Section 18 of the Evidence Act, which provides for, as much as languages are different, customs are different. And in Nigeria, that you have over 250,000 ethnic groups with different and diverse customs, to see how they be in line and in tune with the common consciousness of every person. Hence the need for it to be judicially noticed and be subjected to some forms of tests and whatnot. Thank you.
All right, thank you very much. We had expected your question, and we believe that we've been able to give you a preamble, just like a tip of the iceberg of what your answer should look for. Talking about judicially noticed law and all of those things, we are saying that for customs, for law to become law, they must pass through the customs of the people. Judicially noticed does not make it less of a custom. It doesn't make it less of a custom. Like my colleague said, these are just processes to make these things to be codified, if need be. Because you will agree with me that over time, where customs of certain places appear in court over and over and over again, sometimes they become codified rules and codified regulations to help the people to live a regulated lifestyle. It doesn't mean that they are not customs and then that these things do not exist in the culture. I don't even think this extends that if these things are not in their customs, if their culture does not align with these things, they do not become the law.
Okay, so your submission is that whether the law is potent or not, if it does not align to the culture, it is not law.
Okay, so I'll continue where my colleague just stopped. Now, international law, our erudite scholar taught us on the monist approach and the dualist approach. Okay, so Nigeria as a country adopts the dualist approach. All right, do you understand what I'm saying? So, as a country, we have the right to accept or reject laws by virtue of section 12, sub 1.
Hold on. Take that back.
My apologies for overstepping my bounds.
Yes.
However, by virtue of section 12, sub 1 of the 1999 Constitution of Nigeria, Nigeria has the right to adopt treaties by virtue of the legislature or reject those treaties. So international law are not binding on us as a people. We as a people have the right to accept or reject laws. Do you understand?
Take that back again. Take that back. Take that back. There's no way year 5 students won't understand dualist and monist.
Thank you for understanding.
You're very welcome. So your submission is that it follows that in as much as a law goes well with the culture, it is law. And if it does not, it cannot be accepted as law. Is that your submission?
Even when, I think you are trying to put words in our mouth. Our submission as a group is that laws flow from the customs, the traditions of the people. And there is no law that is not traceable to the history of the people in Nigeria.
Just to add to that, as law student, every time you are being take on any subject of law, like law of contract, administrative law, the first topic is always definition, and the second is always history. This is...
Thank you very much for that submission. At this point, I think we agree on one thing, that if law does not come from the culture of the people, it is not law. Thank you.
Group 6, you're next.
Meeting court. There are nothing will happen. Let's meet in court. Let the steeze of this honorable court be maintained. My lord, the law is embedded in your breast, and therefore we implore you to make use of the discretionary powers to grant justice on behalf of the state.
Most respectfully, my lords, I urge this honorable court to follow the laid down laws My Lord, it is nowhere in our laws that this constitutes an offense. So I urge this Honorable Court to give the verdict in favor of the defendant.
I am the court. Whatever I say remains the law.
Not again. I won't accept this. How dare she lay her filthy hands on my son? Eh? How dare she? Oh yeah, come here. You this boy. You woman, they beat you and you dare like this. Oh yeah, come here. Let me see her. How dare you? How dare you come out here? You this woman, you'll be beating my son. How dare you? How dare you? You know what? I will arrest her. What? What is making noise in my house? What am I hearing? And see this one. See this small one. Well, you are supposed to be in your husband's house. And as for you, you better come back to this house and perform your husband's duties. Okay, now be by church or church. If you think you're woman enough, cross this attention. Cross this attention. You go collect. You go collect. Go and do your worst. Nothing will happen. So like this, these people have grown wings like this, oh. It's remaining very small. My STEEZE is going to drop in this community. I am going to do something. Let me go and meet my friend. My friend. Bang, bang, bang. My friend, oh. Who is there? My friend. Yes, my friend that has forgotten me. Yes, no, so my friend, welcome. Thank you. How have you been now? I dare as you leave me, oh. It's been so long. I'm telling you. Thank you so much. So tell me, this one that your face is like this, what's the issue? My dear, if I tell you what I'm going through, you pity me. Talk to me. Do you know that my useless husband has refused to perform his marital duties? Are you serious? Even after all the beatings I've been giving him. He's getting used to the beatings. Don't worry. Yes. I know what to give you. That is why I came to you. Today is today. We'll receive it hot. You should have come to me since. See, the women in this community are giving birth left, right, and center. And it is all because of me. So let me tell you what you will do. You see this thing, you carry it. When you go to your husband's house, when you go back home, make your husband's favorite meal. Then you carry his water, you open it, pour a little inside, mix it, and give him. When he drinks it, his body will be doing him. But it's not going to kill him. No, now he will not die. Don't worry. Okay. But he will just stagger. Hey. When he's weak like this, carry, drag him inside. That is the deal. Tomorrow, Number one, Kayamata seller. All right, thank you. I feel your vibes, bro. Where's Blessing? a mother. My husband, my sweet husband, my husband, my husband, my husband. Come now, I don't bite. I don't bite. Sorry for the little misunderstanding. You know these things happen in marriage. The glory is on how you reconcile with your spouse. Yes, and on that note, guess what? I prepared your special and favorite meal. Trust me. Yes, yes, yes. I'm still that sweet girl, you know. Of course, of course. Oh yeah, come and eat.
My wife.
Sit down,
Do you really
Jack.
mean that this is for me?
Sit down now. Just sit down and enjoy your meal.
I will sit now. You know
Sit
me.
down, yes.
Are you sure I should sit and eat this meal?
Sit down and eat your food, you know?
My wife. But when did this one start? I hope you're not setting me up for anything.
It's now.
Because what a woman cannot do does not exist. So.
Please, just eat your food.
Okay. My wife.
No last chance. It don't cast you, it don't cast you, it don't cast you. It don't cast, say it don't cast. It don't cast you, it don't cast, say it don't cast.
Wahala dey o. So now wetin some couples they face for inside their marriage be this. Hey! Siba o. Anyway, Mrs. Ayayime Okon has sexually assaulted her husband, Mr. Nyimeke Okon, who is now the victim and has been brutally injured. He lodged a petition and had his wife arrested and tried at the trial court. Unsatisfied with the trial court's ruling, the prosecution has appealed to the Court of Appeal. My people, make we enter inside court, follow your waiting judges go talk on top this matter.
May it please this honorable court, standing before this honorable court is Ayatwa E. Okon, Esquire. I am the Attorney General and I'm appealing on behalf of the state.
Most respectfully, my lords, before this honorable court is E.E. Unenmi. My lords, our appearance for the respondent in this matter.
Most respectfully, my lord, we are bringing our appeal under a singular ground of law that the trial court erred in failing to recognize the principles of natural justice, which mandates protection for all victims of rape, my lord. All victims of rape, irrespective of gender or marital status, my lord, as enshrined in the provision section 1, sub 1 of the Violence Against Persons Prohibition Act. We will also distill our issue under one singular issue for determination: whether this court can overturn the trial court's judgment and sentence Mrs. Ayayime for the crime of rape against her husband, thereby establishing a new precedent that penalizes the crime of marital rape. I would love to, counsel wishes to proceed with this argument, my lords. Most respectfully, my lords, counsel wishes to begin this argument by debunking the common misconception that a man cannot commit rape, that a woman cannot commit rape against a man. That it is also impossible for a man to be raped by a woman. My lord, erection can still be easily induced by threat or pleasure or any kind of without consent, my lord. Hence, violent women like Mrs. Ayayime can easily and dangerously and cataclysmically desecrate her husband's genital apparatus. Notably, the Violence Against Persons Prohibition Act defines the offense of rape without any exception for marital rape, my lord. Therefore, going further, Section 34 of the Constitution of the Federal Republic of Nigeria states that no person shall be subjected to any form of torture or degrading, inhuman treatment. Which other form of degrading, inhuman treatment can be more degrading than Mrs. Ayayime demolishing her husband's dangling testicles? A man would, counsel stands corrected, my lords. My lord, in perpetual peril of rape, what is it? Hasn't she done enough? What is it? Hasn't she done enough? My lord, the torment, the pain, the torture, the torment, the pain, the torture. Is it not enough? I therefore pray this honorable court to make use of its discretionary powers in establishing the offense of spousal rape and sentencing Mrs. Ayayime as penalty for committing such a heinous crime against the state. I rest my case, my lords.
Most respectfully, my lords, who named me upstanding. My lords, it seems counsel on the other side is whining you, but don't panic. My lords, addressing this honorable court, I will base my argument on the singular issue that has been raised already. And I will move further to stating that Section 1 of the Violence Against Persons Prohibition Act clearly states, my lord, in the second limb of that provision, that a spouse can only be raped if impersonated by another.
Just
my
to
lord,
guide you.
Therefore,
your time is up. Just to guide you.
The impersonator is the one who is guilty of rape. Here, the respondent merely offered herself as a sacrificial lamb to her husband. And he's complaining. Why are you complaining? Therefore, I pray this honorable court not to be guided by any misguide from the counsel on the appellant. to give the verdict in favor of the respondent, upholding the decision of the trial court. Thank you.
Thank you so much. The judgment of the Court of Appeal of Nigeria, delivered this day, the 5th July 2024, in the case between Ayayim Okon versus the Federal Republic of Nigeria. Judging from the case before this honorable court, considering the grounds of appeal of the case before this honorable court, reviewing the decision of the trial court, considering the evidence presented before this court by the following counsels, hearing the argument of both counsels on the point of law and facts, considering Section 1 of Violence Against Persons Act, considering also Section 282 of the Nigerian Criminal Code Act, and also considering the case decided by the Supreme Court of Nigeria, the case against YPP versus the state, Okon versus the state, and also considering the various rules of interpretations of the statutes and the principles of punishment, and from the unanimous decision of the judges that are here, Mrs. Ayayim Okon is guilty of rape and battery, which is a very heinous offense in the Nigerian legal system. On that note, by sentence for life imprisonment with hard labor. This is to deter people from further commission of this crime, to correct societal wrong, and to also ensure legal precedent that a wife can rape her husband, and a husband can also rape a wife. This is my judgment.
Good afternoon, the Dean, Faculty of Law. Good afternoon, judges, panel of judges. Good afternoon, members of the high table. Good afternoon, my colleagues. My name is Opara Chidima Favor, a member of Group 6. I'm here to give an overview of the Realist School of Thought. The proponents of the Realist School of Thought were more concerned about law in action than what is contained in the statutes. Justice Oliver Wendell Holmes, who is one of the major proponents of the Realist School of Thought, defined law as what the court would say or do and nothing more pretentious. He said that law is not without the adjudication of the court. He went ahead to give two theories, which is the bad man theory and the layman's theory. The bad man theory, the bad man is not concerned about what the statute says. He's not concerned about what the statute implies. His concern is the decision of the court on his matter. Holmes went ahead to say that statute is a toothless bulldog that cannot bite unless adjudicated upon by the court. He went ahead to also talk about the layman's theory, where he said that the layman who does not know or acknowledge the contents of the statute, but is more concerned with what the court will decide on his matter, that becomes law for him. There are two sub-schools of thought under the Realist School of Thought, which is the American Realism and the Scandinavian Realism. And there are jurists under these two different schools of thought. Under this American Realism, we have Justice Oliver Wendell Holmes and Jerome N. Frank. Under the Scandinavian Realism, we have Alex Hagestrom and Alf Ross. According to the drama that we just watched, we will see that there was no law that was stipulated for rape, for a woman raping a man. But now the court has adjudicated on it and has given a decision. And from henceforth, precedents will follow suit of the punishment given by the court, and that has become a law.
Good afternoon, everyone. My name is Favor Isaac, and I'll be speaking on the relevance of the Realist School of Jurisprudence in Nigeria. My first point will be on the fact that provisions of statutes are said to be lifeless, docile, and dead until they are pronounced upon by a court. An instance is Section 21, Sub 3 of the CBN Act of 2007, which provides against the spraying of Naira notes. Now, you will agree with me that this section has consistently been flouted
The only time when it comes to life is when the court gives a ruling. An instance is the recent case where a popular Nigerian celebrity was sentenced to a 6-month jail term for flouting that order. Secondly, in line with the layman's theory, where it said that a layman does not exactly know what is the provision of the statute books. We can take an instance from the 2023 presidential election case, where the Supreme Court had to rule on whether a candidate had to win 25% vote in the FCT before he could be said to be the president. We can say that the ruling of the Supreme Court in that case established the law on that matter. And then I would also say that when it comes to law, we can readily resort to pronouncements of court instead of having to rely on the long legislative and tortuous procedure. An instance is in artificial intelligence in Nigeria. For example, in Nigeria, there is no specific legislation regulating artificial intelligence. But then, when such instances arise, because they will, do we have to wait for the long and tortuous legislative procedures, or do we resort to the court for quick dispensation of justice? Thank you.
Thank you very much. Standing on the already existing protocol, my name is Stella Henry Dan, and briefly, I'll be taking us on the criticisms, and very importantly, debunking the criticisms against the realist school of thought. There are 3 major criticisms against the realist school of thought, and it is our stance in Group 6 that the realist school of thought stands as the best theory in defining law because it passes the critic test. The first criticism is that the realist school of thought sidelines legal rules and legal principles. In the realist school of thought, the role of the judge is not to sideline rules and legal principles in society. Rather, it is to give them life and give them force, which otherwise they would have been like toothless bulldogs in society. The second criticism is that of predictability. The realist school of thought is criticized on the basis of unpredictability, in that because the judges make law, it is difficult to decide what the court will do and what the court will not do, given cases brought before it. But the principle of stare decisis resolves this issue, because the principle of stare decisis is to the effect that when the court has ruled upon a matter brought before it, the pronouncement of that court becomes the law. And whenever such matters with similar facts arise in any other court of law, the court is bound to play by the rulings and the pronouncement of that court. The third criticism against the realist school of thought is that of applicability and universality. The realist school of thought is criticized on the basis that it emanated from American jurisprudence. So it is popularly said that it only applies in America. However, this is not so, as we have been able to show in the course of our presentation, that not only does the realist school of thought apply in the world, it also applies specifically in Nigeria. The realist school of thought today wins as the best theory because, one, we have passed the critics test, and second, we've been able to show how relevant this theory of law is in Nigeria, in the Nigerian society. Thank you very much.
Thank you very much, Realist School of Law. So before I go into my question, with due respect to the Dean of Law and panel of judges, I would love you to agree with me with these three tenets of the Realist School as scholarly written by our professor, the Dean of Law. First of all, the Realist School of Law believes in the rejection of legal rules. Do you agree? As scholarly written by the Dean of Law, Professor Mojisola is saying. Secondly, the Realist believes in the decision theory of law. Do you agree? Realist School believes in decision theory of law. Do you agree? Do you agree? And thirdly, the Realist School of Law believes in the prediction theory of law. So you agree on one and leave the two. I'll go straight into my question. Thank you very much. Number one, in light of the position that laws are the prophecies of what the court would say, proclaim and declare, and nothing more pretentious, this situation presents court-made laws as the only supreme, unambiguous law. Therefore, in the face of this seeming reality, what is now the state of the Constitution of the Federal Republic of Nigeria, being the fons et origo of all laws, and by extension, creates and empowers the courts through Section 6 of the Constitution of the Federal Republic of Nigeria? Please answer.
As posited by the Realist School of Thought, legal rules and legal principles are not sidelined. However, it is the role of the court to give life to these legal rules and principles. The Constitution is not exempted. The Constitution remains it remains a codification until the court breathes life upon it. That is why we have such sections. You have the chapter 2 of the Constitution that cannot be enforced.
And also, in line with your question, according to John Gray Chipman, he says that the other forms of law can be said to be sources of law, but it is actually law when they have been pronounced upon by the court. And also, we want to say that when it comes to the Constitution, the system of adjudication existed even before the Constitution was enacted. So without the Constitution establishing the court, there was still a system of adjudication. Thank you.
So, assuming without conceding, the first speaker said the Realist school of thought does not sideline the Constitution. Are you now giving credence to the Positivist school of thought, which agrees on written law? You actually don't have to answer that.
Okay, just to clarify our position in the Realist school, we are not sidelining society and its rules. We are saying that the rules of society are given life by the court. Therefore, what makes them come alive, what makes them living law, is the fact that the court has adumbrated and has made a decision on them. Thank you.
However, just to clarify further, I would love you to understand that the Constitution has its life once predicted upon by the court. No provisions of the Constitution has life except once the court have given interpretations. For instance, in electoral matters, where the Constitution had made provisions for 3/3 plus 25 states. Now, it is the provisions, the decision of the court, that was just the decision in the just concluded election. And that has now become the status, that has become the law. Whenever such matters arise, it is the decision of the court that is relied upon and not the exact provisions.
Okay. So for the clarity of our learning colleagues in the gallery,
ask your question.
Your submission is that court-made laws supersede over the Constitution.
Is that your
Thank you very much.
question? Ask your question.
Yes, I would answer that in the affirmative.
Thank you very much.
Okay, thank you very much, the Realist School of Thought. So, you agree with me that your school of thought posits that outside court-made laws, all other laws are more like, are definitely less bulldogs, that the court is what makes law. Emphasis on, they're the one that makes law. That's what your school posits.
All right.
That it is the court that makes the law.
I think you are misconstruing the whole scenario. The Realist school believes that there are laws in existence, written down, maybe historical, other kinds of laws, for instance, customs and traditions. Now, those customs and traditions are not law until the court has pronounced so. For instance, what about the repugnancy test? That makes that once a custom has been brought to the court and decided, that custom is judicially recognized and that becomes law. You cannot quote a custom if it has not been judicially recognized. Now, the provisions of acts, even if the National Assembly makes a law tomorrow being Saturday, now that law is a toothless bulldog, because if for instance, if it penalizes a crime, if you have not been arrested, you cannot even be arrested and sent to prison and remain there. You have to be brought to court. And if the court says you are not guilty of that law, that becomes the law. If the court says you are guilty of that law, then it is now the decision of the court that is the law. And that is what is relied upon. Thank you.
Okay, please.
You have one last question.
Let me put clarity.
You have one last question.
One question. I'm putting clarity. They are not responding accordingly.
Ask your. We are the ones to determine.
Okay, so
ask your question.
You agree that
is that your last? That's your last question? Anything else you say will be taken as a question. Agree.
You agree that legislations are laws, but they can only come to life when interpreted by the courts.
Docile laws, and they come to life once interpreted upon by the courts.
Before you answer that, let me give my final question because of want of time.
We have answered. Thank you very much. Thank you very much.
All right.
Thank you.
To lay emphasis to that, we had mentioned in the course of our presentation of two theories, the layman theory and the bad man theory. So to the bad man and to the layman out on the street, he doesn't know what the statutes say. when he does an act, whether it's a crime or not, when he does those bad things that he doesn't know that those things are exactly a crime until when he is arrested and he is taken to court and the court says, yes, you have done something wrong. That is when it becomes a law to him.
All right, thank you very
Also,
much.
we must also understand that the bad man, following the bad man theory.
Gifts, you have no right of audience again. That's okay, that's okay.
I believe.
That's all right.
I believe.
Believe, continue believing. Continue believing. Shay, you gave us biology lessons.
Judicial review gives right.
Trendybeats.com.
Every day when I've been knocking, every time when I've been walking, steady grind, you won't tire me. But if you quit, I'll do for mommy, yeah. Sometimes food no they give my shape, but can't hear out the feeling is different. I'm a shaky man, no lose God, you know the laughing bullshit. My life go hard, I might not want to do bad, cause I know what's up all the time.
Of the greatest Nigerian students. All right, so in our midst today is our exams officer, barrister, CEO, capacity exams officer. I am borrowing the words of the dean. Barrister Ndudie Oton, please put your hands together for her. We also have the presence of the Assistant Chief State Counsel, Mrs. Hannah Michael Udofia. Please put your hands together for her. Ladies and gentlemen, we will also be recognizing the presence of the #1 person in the Student Union government. He is the 001. I expect you to be clapping by now. He is none other than Dayemi Achibong. You're welcome, sir. We also have the presence of Barrister Promise. Barrister Promise Ochibri. Please put your hands together for her. Group 7, your time starts now, please.
I don't even trust those guys.
Yeah, no, I don't tire for you.
He's back in the crowd. He's back.
day, ma'am.
Good day.
Ma, I'm calling you from Maximum Composure Bank.
Bank. My daughter, what is the problem?
Ma, please, for my system here, I can see that your date of birth is not corresponding with your BVN.
I thought it's great. My daughter. Yeah? I gave that brother in the bank everything. Yes, in the bank. I remember I was there.
Yes, ma. I'm working on it now. Please, can you hold on a minute? Ma, please, can you call the last 4 digits of your ATM card?
My bank.
Hello, ma, are you there?
Yes.
Please call out the 4 digits.
Enemy for progress. Hold on.
51
53.
23. Okay, ma.
Please, my daughter, help me. Please.
Yes, ma.
Josh money is in that.
Yes, ma'am. Ma, this is our job. Hello, ma. Please, you just received an SMS. Please call out the code for me.
Okay. Yes.
55 32.
Yes.
Okay, ma. Please, once it's rectified, you will get a message from the bank. Thank you very much, ma.
I'm here to intimate us on the fact that this administration is not ignorant of what is happening in the Nigerian society. We are at societal needs. These are the premises on which we exist. And so we will not relent to combat societal menaces, and we always enact laws to ensure that the law evolves with the society. Thank you very much.
Welcome to Jurisprudence TV, Channel 7, Uyo. The headlines: SARS out, SWAT in. Government moves to rebuild public trust. Cybersecurity gets top priority as Nigeria enacts new law. Good afternoon. I am Mojisola Hansen. Now the news in details. In response to the widespread protests and outcry over the brutality and human rights abuses committed by the Special Anti-Robbery Squad, SARS, the Nigerian government has dissolved the controversial unit and announced the formation of a new tactical team called the Special Weapon and Tactics Team, SWAT. Our correspondent, Daniela Rega, reports from Abuja.
So not a fight for my life, it's alright because everything dies. Nobody know why. Nothing you go do when you're feeling like you're falling and you can't find nothing to hold on to.
Let's hear from another willing mother.
Sorry for the interruption. Moving on to the next story, Nigeria has strengthened its cybersecurity laws with Cybercrimes Act. This law aims to combat the growing threat of cybercrime and improve global cooperation in investigating and prosecuting cybercriminals. That's the story we have today. Once again, I am Mojisola Hansi, reporting from Jurisprudence TV. Tune in, same station, same time, next session. Thank you.
Good afternoon. Good afternoon. Good afternoon, the erudite Dean of Law, the learned Vice Dean of Law, our esteemed judges, and distinguished ladies and gentlemen. My name is Diana Charles, and my colleagues and I are going to be talking on the Sociological School of Jurisprudence. I'll first take the introductory aspect, while my colleagues are going to be taking the basic tenets and the applicability of the Sociological School of Jurisprudence in the Nigerian legal system, respectively. The sociological approach to the study of law is concerned with the functions of law in society. It rejects law as an abstract or idealistic concept. It posits that law should not be studied in its abstract form as it is contained in the statutes book, for instance, but rather its primary consideration should be the function of law in the society. So basically, our school deals with the relation between law and the society. Moving forward, the basic proponents of this school are Roscoe Pound, Rudolf von Jering, and Eugene Ehrlich. For want of time, I'm going to give a brief summary of the view of these proponents with regard to Sociological School of Jurisprudence, beginning first with Roscoe Pound. Roscoe Pound is regarded as the father of Sociological School of Jurisprudence. The two aspects of Sociological School, the two aspects of Pound's analysis of law is that, one, law is an instrument of social engineering, and secondly, he regarded the role of law as that of balancing the conflicting interests in the society. Jering, on the other hand, was of the view that the main purpose of law is to serve the needs of the society. He also went ahead to say that that law is a means to an end. And what is this end? The end here is social control. And finally, we have Eugene Ehrlich. Eugene Ehrlich was popular for bringing out the term the living law. The living law, according to him, is the actual practice of people the actual practice of the law in the society. So this is going to be expanded on in the basic tenets. Thank you.
Thank you very much. Good afternoon, everybody. Please permit me to stand on the already established protocol, and I'd like to refer the audience to our slides. And so as earlier is introduced, my name is Enina Fortune Chinwekele, and it is a privilege to address us on the basic tenets of the Sociological School of Law. And so before I list out and explain these basic tenets, I'd like to underscore the general idea of the Sociological School of Law. which is the role and functions of law in the society. Against this background, I list and explain the basic tenets. First, the Sociological School of Law holds that the law is an instrument of social engineering. Ladies and gentlemen, this simply means that the law is a tool to the lawyer. And in this context, I refer to the actual lawyer, the judge, and even the lawmaker in fixing societal issues. And this may be likened to an engineer in the society who fixes mechanical and electrical issues. This is a metaphorical expression as posited by Roscoe Pounds. And secondly, it is our view that, it is our belief that the law is an instrument of social control. Ladies and gentlemen, the law in its authority, the law in its efficacy is to regulate life and conduct in the society. Thirdly, the law is a tool to, to create a balance between conflicting interests. As we're all seated here, I give an analogy that we have interest in our rights to own properties, and of course there is the right on the part of the government to manage land for public's interest. And so the law plays a role to create a balance between these two competing interests. Ladies and gentlemen, the idea of living law, as postulated by Eugene Ehrlich, is very important here. And so, living law simply refers to the actual practice of law in the society. This further advances the idea that as much as the society is dynamic, as much as the society evolves, the law must evolve, and the law must adapt to social conditions. Ladies and gentlemen, lastly, for want of time, I like to state that the Sociological School of Law holds that in the making, interpretation, and application of law, we must consider, take cognizance of, and take into account social facts. These social facts are the premises on which the society exists, and so the law must meet these ends. Thank you very much.
Good afternoon, everyone. I'm Udodre Moekachi. Permit me to stand on already existing protocol. I shall be taking you on a journey of analyzing sociological jurisprudence on Nigeria context. So, like debated in our drama, we clearly see that as a result of police brutality, intimidation, and the rest, this also necessitated several unrest, whereas the government, passing its public social policy, also enacted a law in conformity with the social realities, of course, which necessitated the proscription of special anti-robbery squad, which is popularly known as STEEZE. Furthermore, we have also seen from the drama, which was also displayed, that a particular village woman who has no knowledge of the technological advancement was fraudulently, of course, taken advantage of. This in reaction, the government also took a decisive action by enacting a law which is also known as Cybercrime Prohibition and Prevention Act 2015. Furthermore, also in order to buttress this point, we also see in Benue State, where because of the constant clash between the farmers and also the herdsmen, the government of Benue State enacted a law which is known as Anti-Grazing Law 2017 in order to balance these activities. Furthermore, he portrays that law also serve as a balancing social interest. Of course, I have to take you to the journey in our constitution. Section 43 of Nigerian constitution as amended clearly stated that private individual, everyone is entitled to own property. Whereas section 44 of the same constitution also empowers the government to compulsively acquire individual property, most especially land, for overriding public interest. Furthermore, we also have to take cognizance of the Land Use Act, which also came on board in 1978 to balance the social dynamism in the society. What does this law entail? This law, furthermore, empowers the government to acquire private laws in order to also establish or meet the public demand. Also, we are conversant with the law of the thought of nuisance.
Please round up. Please round up.
The thought of nuisance tries to strike a balance between right of a individual who has possession and also another individual who has a right to commercial activities. At this point, I have to give my colleague to make the conclusion.
Thank you very much. And to conclude, ladies and gentlemen, I'd like to refer us to the preamble to the 1999 Constitution of the Federal Republic of Nigeria. I have interest in the first line. We, the people of the Federal Republic of Nigeria. Very importantly again, is the purpose of that constitution, which is to provide for ourselves a good government and to promote the welfare of the people. We provide this constitution for the people. Ladies and gentlemen, this is the law enacted to cater to the needs of the people based on the consciousness of what is prevalent in the society. The law is a product of social construct. The law is a product of social order.
Thank you.
The law is a product of societal needs. Thank you very much.
Okay, thank you very much, Group 7, the Sociological School. My question is, it goes like this. In the making and interpretation of law, you guys have said that the law must take into consideration social facts. So what then is the justification of law for altering existing social facts and changing societal norms rather than reflecting them?
Thank you very much for that very knowledgeable question. However, a deeper knowledge would reveal that amendment of law is to reflect and not to alter. So when we alter what is contained in the Constitution, it is to reflect the social realities of the time.
Okay, the proponent of your school of thought, Roscoe, also in trying to talk about this sociological theory of law reflecting the interest, talked about 3 types of interest: public interest. Okay, let me hand it over to my colleague to ask.
Okay. So thank you very much, Sociological School of Thought. And once again, with due respect to our honorable judges, I'd like to ask that Mr. Ododirim hinged his submission on a non-existing repealed act. So the Cybercrime Act has been repealed. You hinge your submission on Cybercrime Act 2015. There is an amended Cybercrime Act of 2024. So please, for correction. Then, let me go on with my question. Thank you very much. This is a logical school according to Roscoe Pound. This is a logical school according to Roscoe Pound argues that law functions to balance competing interests within the society. Agreed? Yes. Okay. How can the sociological school explain these situations where the law seemingly favors one interest group over another rather than achieving a perfect balance? To help you, I'll give you instances. First, the Child Rights Act 2003 sets a marriageable age to 18 years and at the same time prohibits child marriage. Secondly, the Nigerian Police Force Regulation 127 aims to discharge unmarried female pregnant officers. Unmarried female pregnant officers, as against no restriction to male unmarried officers that have children outside marriage. So please, competing interests.
Thank you very much for that beautiful question, I would say. Yes, you're welcome. You had answered your question, and I'll tell you how. You started by saying that the Sociological School of Law believes in the instrumentality of the law in creating a balance. And so where we consider a pregnant female over a male, we are creating a balance between these two persons in the order of priority. In the order, yes, that's our priority. Yes, that is it. In the order of priority.
Okay, thank you very much. In addition to what he has said, I want to believe that we are acquainted with the knowledge of the law, that you don't interpret a particular section of law in isolation of the others. This also has to balance the situation in our constitution, where the majority age is 18 years. Furthermore, if you look at the Nigerian context, in order to balance the societal interest, which you succeeded in answering as well, you will also believe and also note the fact that the parents of the child has interest in the child. And also, in order not to corrupt public morality and also public welfare, the laws try to balance the conflicting interests. What is the conflicting interest here? Trying to protect the right of the child in order to avoid abuse of the child. So there is no other way. You cited the issue of cybercrime. Cybercrime, we are talking about the law. If you listen very carefully, my colleague here says formal law. What are the formal law? Of course, it is the belief of this sociological school of thought with all affirmity that law emanates from the society. The formal laws are the laws. We talk about the redundancy of the law. Let me also take you to this legal journey. In DPP against Shaw, the court clearly stated that law evolves with the society. Law does not exist in isolation. Thank you.
All right. So to give your position context, your idea of balance is that the police regulations 127, which gives more favor to male unmarried officers that have children outside marriage, other than that which is already provided, which discharges female unmarried pregnant officers. Is that your idea of balance? No, it is a yes or no question.
No.
Hold on.
Sir, the law is very simple.
Hold on. Be decorous even in asking questions and in answering.
Okay.
You don't tell them it's a yes and no question. No, you've asked. And you too, you're almost jumping off that stage. Calm down. Answer your question.
Okay, sir. That is a nice, intelligent question. If you also observe my submission, I told you that you don't interpret the law in isolation. I want to know that as a final year student, you should know the provision of section. Okay, sorry. The provision of section.
Take back that statement.
So I retract the statement. Sorry, my lord. Section 42 of 1999 Constitution as amended clearly provides that no person shall be discriminated on the ground of sex, religion, etc. This simply means that that particular section that you are relying on is not applicable by the provision of section 42 of Nigerian Constitution.
You have
also
wait. Okay. You have misunderstood his question. He said he's asking you. Okay.
So for that question, we leave it to our judges. I will go forward to another question. So you should be well acquainted with our jurisprudence and cases that are flying here and there. So in a recent case, the Federal High Court struck out a matter filed by the NBA, which aimed at striking out Regulation 127 of the Nigerian Police Regulations. So understand that the NBA took to court.
Are you asking him a question?
I'm asking a question.
Ask him now.
So, in conclusion, the Federal High Court struck out a matter with the justice saying that those female unmarried officers knew the police regulations before joining the job, and as such, held that the Nigerian Police Regulations Rule 127 is valid. So I really don't understand what you're saying, but we'll leave that to the judges. Finally, for my last question.
I asked
it's providing clarity. It's providing clarity.
You're not the one to provide clarity.
Let me ask my question.
Hold on. Okay. Don't do that. When you come out here, ask a question. Just one more. Just one more question from you.
So, Mr. Fortin Chinwekele, you in your exposition, you laid reference to the Constitution of the Federal Republic of Nigeria, the preamble saying "we the people." Are you trying to say that in whatever the sociological school of thought does, they must always pay respect to the Constitution of the Federal Republic of Nigeria?
the people is a reflection of the society. So when the society makes this law for them, whatever comes later is with reference to them. Whatever comes later is to cater their needs. And should there be a reason to reflect the new social order, we, the people, would also amend the Constitution.
Meaning that, in conclusion...
Gift, will you stop that? Stop that. Thank you very much. Thank you. Thank you. Well, Gift them are the aggressors, so, but don't be too aggressive. They are the aggressors. Thank you, group 7. Please call group 8. Group 8 is the last group. Thank you, group 7.
Group 8, your time starts now, please.
Please tell me.
I went to your bill you passed last month. Okay, my increase salary in your judiciary by 300%.
Are you serious? Meanwhile, here is NLC.
Oh, my friend just sent me a happy check. I mean, why NLC is here going on strike for what I don't even know? A measly 100,000 naira.
Very miserable.
The poor never see anything.
They're not supposed to even see money first.
I mean, STEEZE go choke the poor.
Wait. Is that what people are saying? This positive.
You're positive. Okay, law is made by an uncommandable commander. Okay, mean the uncommandable commander.
Yes, now. Now who get money they command? Who goes then?
I mean, who goes then?
Who goes then?
They never born.
What is that?
You don't go sociological.
And here we go.
Law machinery for social engineering. 5 years. It's engineering. They corruption.
I put it to you that money moves society. What money cannot do, more money can do.
What money cannot do does not exist. And
what is that? This law not even pure. Wait. Speaking of pure, Mbono pure me, pure theory.
It is an spirit.
How can somebody tell me? How can somebody tell me that law can be derived is a set of norms, can be derived from a ground norm? How can you tell me that law is devoid of morality, of religion, of ethics? How can there be law without money? Who doesn't even have money? Not try me. Not try me.
Money. When I have money.
If you don't like it, take me to court. I know you have heard. The realists, they are telling you that law is what the court says and does. And also pretentious. Let me tell you, I can buy a judge. I buy the judgment. I own the judge. Who goes you? Who goes who I am? Are you okay? Are you okay? Check the history. Check it.
Speaking of history, your historical school.
What are they?
Okay, law stems from a historical event. Okay, historical event. Slavery. Osuka system.
What is that?
Killing of twins.
What is that?
Who
owns the twins? Who owns the slaves? Is it not the rich?
It's only natural.
It's only natural.
Speaking of your natural
who are they?
Okay, don't go cut with 9 lives.
They will die today. See, make I tell you, Marxist go oppress you. But no fear. That's no challenge.
That's the only hope for the common man. I mean, a cashless society, I be a good borrow.
Who go give them?
Let's see how we to play out, sha.
Don't mind them. Make we they go. Let's say something.
How we get them born the most.
Chantel and Cope, so you cannot greet. Chantel, please, it's okay, just sit down. We are going to continue from where we stopped the last class. We'll submit our assignment, so please, I don't want to hear stories today. Please, Chantel, we'll submit our... Young lady, can't you see? What is wrong with you people in this class? What exactly is wrong with this class? It's okay. It's okay. It's okay. Let's continue, please. Where did we stop? Someone should remind me where we stopped, please. Where did we stop? This class. Oh my God. You are coming late. What is wrong with this school? What? You're just coming now. What is this now? What is this? What is this now? Apple. What is this? Leave him alone now. Where are you taking him to? Oh, these children. Where are you people taking him to now? What is this?
So, madam, like I told you, you have absolutely nothing to worry about. This thing has been handled. You know, like I said before, we shouldn't have let these riffraffs in the first place. That money that was, channeled towards...
You better handle this.
Ma,
you know how much I'm paying in this
I understand
Without me, this school will not be in existence.
You understand,
Handle
ma.
this matter.
I understand you, ma. I completely understand you, ma. I know she did not do it.
I know my daughter,
Ma,
and I raised her very well.
We are in charge. We are on top of the situation. I am loyal to you, ma. We're completely loyal to you. You know, without you, we can't do anything. Of course. I mean, the scholarship team, because of you and other parents, I don't know, it will not happen again. I assure you that we're on top of the situation. We're on top of the situation. It's really unfortunate. All these, wretched children from wretched homes and wretched foundations and wretched backgrounds with wretched histories. That's it. That's why they're not given any opportunities. That's why they remain poor. I understand you. I understand you. And I assure you, to the utmost of my ability, this will be taken care of. You have nothing to worry about. I mean, it's really sad. It's sad how it played out, but it's okay. The girl in question is dead. She's dead, so she cannot be further punished. But it's okay. She got what she deserved. She got what she deserved. Yes, she did. She did. So don't worry, ma. You have nothing to worry about. Oh, my goodness. Honorable Minister, ma. You're welcome, ma. Ma, you absolutely did not.
You know who my husband is. What is all this?
I apologize, ma. Ma, just.
If naira cannot solve it, dollar will solve it. If dollar cannot solve it, pound sterling will.
Yes, ma. Just a small donation will clear all of this. Honorable Minister, ma. I'm very afraid to come close to you right now because of the person behind you, but I assure you, it's true, ma. It's true, ma. Very true, ma. But I also want to assure you, ma, that the wretched girl in question doesn't even exist anymore, so you have nothing to worry about. I will handle it, ma. Your Excellency, we are loyal. We're loyal to you. I mean, I hope I've satisfied you, ma. Just one small discussion, ma. A very small donation would... Who is that? Madam, excuse me. Madam, we are on top of it. Madam, can you hold on? Madam, we don't tolerate it. Hello? Excuse me, madam. Hold yourself, madam. You cannot constitute. Who let this wretched thing in here? Excuse me, madam. Madam, I don't know what you're doing here. You should not be here. Your daughter is responsible for all of this mess. I mean, look, excuse me. The Honorable Minister has, out of the benevolence of her heart, offered you a whooping sum of 200,000 naira and funeral arrangements. I mean, you should be grateful. Please. We've done a lot for you. We didn't let you wretched people into this place. All of this will not be happening in the first place. Honorable Minister, you have nothing to worry about, ma. It's okay, ma. It's sorted out. They are not a threat to you at all. Who is she? She's nothing, ma. It's okay, ma.
Agriculture, and then we tell you that your land belongs to the federal government. The Land Use Act. Until we can achieve a classless society, the rich, like us, will always oppress the poor, like them. So today, the members of Group 8 have come to say no to...
Good afternoon, the Dean of the Faculty of Law. Good afternoon, other lecturers of the distinguished Faculty of Law. Good afternoon, the panel of judges, distinguished colleagues, ladies and gentlemen. My name is Joseph Boas, and we are here to espouse on the Marxist School of Jurisprudence. From the drama piece you've just watched, you can see that the drama piece depicts the character of the society as espoused by Marxism, in which the school represents a microcosm of society which is supposed to uphold justice. But because it is the rich of the society that sponsors the school, they have been able to screw the law to advance the selfish interests of the bourgeois class. And that's what you've just seen. Even when someone was dead, the dead became the accused. That is the error in society that Karl Marx and other proponents of Marxist school have come to address. And so the Marxist School of Jurisprudence is hinged on three basic assumptions. First is the fact that the law is the product of the economic forces of society. By this, Karl Marx opined that the society is stratified along the bourgeois class and the proletariat, the bourgeois representing the elite class. And so those who are in the bourgeois class have access and, in fact, the monopoly of economic power, and by that, they are able to influence the law, and the pendulum of law swings in favor of the bourgeois class. Second is the fact that law is an instrument in the hands of the bourgeois class, the elite class, who make law to favor and advance their own interests at the expense of the interest of the generality of the masses. This point is buttressed in the Nigerian society, whereby laws are made to advance the interests of the rich. And of course, law enforcement agents, for example, the police, is meant to protect the society, but in reality, the police protect the rich and the mighty, banks and politicians. Where then is the place of the common man in the arrangement of things vis-a-vis the law as it is practiced in Nigeria? Finally, Karl Marx also opined the withering away of law. By this, Karl Marx opined that a time comes when the proletariat, the masses having been pushed to the wall, are going to revolt. That revolution is going to outpace the Marxist school, outpace capitalism and the entrenchment of communism. And with the entrenchment of communism, there will be no need for law, because the society will be run on the basis of unity, hence no need for law. Thank you. It is therefore posit that Marxist School of Jurisprudence has STEEZE and composure.
All right, my name is Shelley Young. Now, the Marxist that we know comes from the idea of Hegel. Hegel was the one who developed the concept of dialectics. Dialectics means the theory of the unity of opposing ideas. Hegel believes that the society we live in is based on conflicting ideas. Thesis conflicts with antithesis, resulting in synthesis. Thesis there means an already established idea. Antithesis there means an opposing idea, while synthesis means the resulting idea. Karl Marx was attracted to Hegelian dialectics because Hegelian dialectics was a reflection of the contradictions that are present in society. However, he was against Hegel's idealism. He replaced it with materialism because, according to him, society, the development and change in society is not caused by ideas, but by the economic forces in it. After this, the social factors or the means of production in society moves to one side, while labor moves to the other side, leading to an inequality in society. All of this translates into politics, where laws are made to serve the interests of the rich against the poor. You can find such situation in the Constitutional Code Act. For example, Section 37 of the Criminal Code Act provides for the crime of treason, making it a crime punishable by death. Section 402 of the Criminal Code Act provides...
Please round up, yes.
Section 402 of the Criminal Code Act provides against robbery, making it a crime punishable by death as well. Section 390 of the Criminal Code Act provides against theft, making it a crime punishable by 3 years, by the least of 3 years imprisonment. Now you can ask yourself, who are the people?
Please round up. You've made your point. Just round up. Round up so that the next person can...
Okay. The goal of Marxism is, and it has always been, the goal of Marxism is and has always been to destabilize the status quo and establish a classless society for us all.
My name is Ofo Modesta, standing on the existing protocols. I'll be taking you on the realities of Marxism in the Nigerian society, and I'll be doing this under 3 headings: the Nigerian law, decisions of the courts, and the policies and practices of the states. The Nigerian law, a typical example of Marxism, is mirrored in the provision of Section 15 sub B of the Money Laundering Prohibition Act of 2004, wherein the law provides for the penalty of a term of 2 years imprisonment with the option of a fine not less than 250,000 naira and not more than the cost of 1 million naira. This, by implication, posits that people who can afford to pay these prices can get away with committing these crimes. When you have money, why not just pay and stay out of jail? Another way that we can see Marxism materialized in the Nigerian legal system is through the decisions of the court. And a typical example was seen in the case of Adesina against the state, wherein Mr. Mustafa Adesina was charged and convicted for the crime of theft of vegetables worth 5,000 naira, and he was convicted on the charge and penalized to pay the sum of 10,000 naira, which was double the price of what he stole, or the option of 2 years imprisonment. He was unable to pay the price of 10,000 and went to jail for 2 years. For the reality of Marxism in the practices and policies of the Nigerian state, a typical example is seen in the privatization of the power sector in Nigeria, wherein the facade of privatization was used to cover the enrichment of a particular group of people, thereby enriching the rich further and increasing the electricity bills. This also causes suffer and causes oppression among the poor masses. Now we can see, just like the theme of our play is Temedigie, a Calabari term for mirror. The Nigerian society mirrors Marxism in its full form. Thank you.
In conclusion, the point that has been buttressed by our presentation...
I think you've made your point.
Okay. Questions?
I think you've made your... Okay, you want... I think you've made your point.
Thank you very much. I like that presentation. It's actually very nice. So the first question is this: what is your position? Are you in support of the Marxist school of thought? Are you saying the Marxist school is supreme over every other school of law? That is the first question.
Absolutely. The Marxist school is supreme because it comes to disrupt the status quo and entrench a classless society where you will not be suffering and everybody in society will have a level playing field. The same way that members of the National Assembly have a level playing field where law will serve the common good, where law will become the last hope of the common man. That is not the reality, but that is what Marxism wants to be entrenched. So yes, Marxism is supreme.
Your answers are actually complicating. You said something. You said I'm suffering. No, that's what you said. You said Marxism wants to free me. Marxism wants to free me.
Hello,
are you listening? Okay. Now my question now is this: You said the Marxist school of thought believe that the society is going to change from capitalism to socialism and then communism, which is where we're going to have a classless society. A classless society where there is no law, and where there is no law, there's no regulation, and what it means is that there's not going to be fight, and there's not going to be any form of conflicting interests. Now, my question is this: isn't that ideal abstract in nature? And how is it applicable in the current Nigerian situation now? Is it possible for us to exist in Nigeria without having conflicting interests? That's my question.
The reality is that Marxism prophesied, it was a prophecy. Hold on, let me answer your question, please. Now, when you look at what happened during the NSAS, that is what Marxism predicted. When you look at the Arab Spring, the revolution that ousted the then Egyptian president and other presidents, that is what Marxism predicted. And yes, Marxism predictions have come to pass. So, like I have told you.
Hold on. Also, give her opportunity to answer. She also wanted to speak.
I believe that Marxism is not just a prophecy, it's a reality. And we live in that reality in the Nigerian state.
Okay, while you were presenting, you mentioned some laws that actually...
Are you the only one that is going to ask for your group?
No, I'm not the only one.
Because after yours...
That is the last question.
Yours is the last?
Yes. No, this is the
for
last
you.
For me, yes.
Do you know what time it is? Let
Okay.
others also ask, except the
Okay, your emphasis is that law is an instrument of oppression and influence. Okay, how can you balance this with Marriage Act, Will Act, and the Child Right Act in Nigeria?
I believe that law is an instrument of oppression. And even those laws that are painted to look like they are in the interest of the poor masses, when need be, when the rich want to, they will use it against the poor masses.
Okay, my second question is that you said to you, Sir Boaz, that you actually...
Sorry.
Okay.
One more question.
Okay, one more question.
So I agree on who will ask.
Okay, from your role play, you've clearly shown us that law is considered to be the tool of the ruling class to maintain its power over the working classes. Now, considering Section 17, sub 2, paragraph A of the 1999 Constitution as amended, which states that every citizen shall have equality of rights, obligations, and opportunities before the law. Also, in Article 7 of the Universal Declaration of Human Rights, affirm the same position. Now, how would you reconcile those laws with your school of law, bearing in mind that it is the theory that gives power to the ruling class over the lower class?
Now, let me enlighten us that let's separate the propositions from the reality. For Marxist school of jurisprudence, the law is expected to, but that is not the reality. And that reality, which is that of oppression, is what Marxist school has come to dislodge. Now, the reality is that, hello?
Hello. Sorry. Please, I would like to take that question again.
He has asked you.
Yes, I had the question. I want to take it from the beginning.
All right.
So, we believe that Marxism, we insist that Marxism is a reality that we live in. And considering the sections of the law that you cited, I still insist that even though these laws look very pleasant and caring towards the poor, I believe that when the rich want to and when need be, they will use these laws against the poor.
In addition to that, you said people have rights. In the Constitution, in as much as they have given us provision for rights, they have also provided ways that the rights can be abrogated. And who makes these laws for the abrogation of rights? The ruling class. When we talk of freedom of movement, when the ruler has to declare state of emergency, that is also abrogating the rights of the masses. We talk of rights to life. We mentioned Section 37 of the Criminal Code Act, which talks of treason. Who are the people that will commit treason? The poor masses, because they want a revolution. They want to overthrow the ruling class. They want things to be free for them. They want things to be equal for them. And what did they give them? The punishment. The punishment is death. Why are they giving them death punishment? Because they don't want the status quo to be changed. They don't want anything to change. They want to still be in power. Because in Marxism, we believe that the economy is the substructure of the states. And every other thing, religion, morality, every other thing is the superstructure. Even law is superstructure. So the ruling class will make laws to oppress the masses, the poor masses, so that they can still be in power and so that they can still oppress them further.
Thank you. Thank you. Thank you. I thought you wanted to take a bow.
The world diverse. Your names will open doors for you. Don't bother. Your name is Ihani. Nothing is impossible with God. Your name is Chinemerem. God will do it for you. Oh my heavenly Father, make a note on to certify on my back on my course. Cause my past is making me sober. So even if it is like 100 of I could take over. Oh my heavenly Father, make a note on to certify on my back on my course. Cause as I am fighting for my survival, wherever there is peace and harmony, I will go. Cause whatever you say goes, whatever you will, I say so. But let me be sincere with you, this movie, no this sweet. But I'm trusting on your will. I follow for your best, cause whoever that is running without you, stay so. Let me tell you the story of the boy that he hustle and bustle from the job. With the hustle, feel make you could lose your senses, but I'm not return the vote. What shall we do to life?
Good evening, ladies and gentlemen. You would agree with me that it has been a beautiful, amazing, wonderful performance, put out by the Year 5 class. I do not like the fact that I just said that, and it is only the Year 5 class, those who labor to put up this show, that is clapping. My classmates are quite deserving of that, applause, because we had just a couple of days to put this together, and you've seen how beautiful it has been. So right about now, we're going to be taking commentaries. So the very first commentator that we're going to be having is someone who is a postgraduate student of the University of Uyo Faculty of Law. She is none other than Peace Ochibri. So please put your hands together for her as she comes forward. Promise Ochibri, please. I'm so sorry. My name is MM, and it literally translates to peace, so you can understand why I made that mistake.
Thank you very much. Good evening, everyone. Sitting here today has been nostalgic for me because 3 years ago, I was also in this same position, And I dare say that historical school of thought deserves the crown.
Please retract that statement.
Okay,
Sorry,
I'm
sorry.
saying that because I was of the historical school of thought.
Retract it, please.
Okay, I
With due
stand to be
respect
corrected.
You are
I
trying
stand to be corrected.
yes, that's
no
prejudicial.
school of thought is supreme yet
Thank
until
you,
the
thank
judges declare that.
Yes, thank you so much.
Okay, I dare say that there is no better testament of the fluidity of the law than what we have seen today. There is no better presentation of the fluidity of the law. To me, I see the law like water. Anywhere it goes, it picks something with it. You see it in the positivism. Look at our constitution. They tell you that it is what the law says that is. Look at the realist school of thought. Look at the sociological school of thought. Look at the historical jurisprudence. Look at our customs. Then come and look at our legal system. You see that the laws we have today emanated from is a combination of the common law, judicial precedent, the Sharia law, and our own customs and traditions. So if you are looking at the law, to come at a conclusion on what the law really is, to come to have a clear understanding of what the law really is, you have to look at all these schools of thought and then bring them together in order to accept that, yes, to me, like in my own opinion, I'll tell you that there is no school of thought that crowns it all. Because the law, like water, goes about picking from here and picking from there. Now, looking at AI, there have been, everywhere you go, you hear AI, you hear about artificial intelligence. The question is Nigeria ready for artificial intelligence? As it stands now, we do not have any laws regulating artificial intelligence. We know that man from time immemorial has always been on a quest to outdo himself. And this is what gave birth to artificial intelligence. And just like the fluidity of the law, artificial intelligence is just like that. Because it just started from, we will talk about ChatGPT, just give a command, and ChatGPT will do what you want it to do, down to robotics, where you have robots coming to do what you want them to do. The question now is, can a robot practice law in Nigeria? The answer is no. Because according to the Legal Practitioners Act, before anybody is able to practice law, it must first of all be a person. And then you must have been an undergraduate for at least 5 years. And then you must have gone to law school. You must have also been called to bar. And as we speak now, there are no laws to regulate the use of AI, apart from the ethics of AI. So, what I want us to bear in mind now is, when we are carrying out our researches, we should also come up with our own formulations. I know that, yes, we should also come up with our own formulations, our own ideas on what should be in order to regulate AI. Because I think a couple of months ago, there was this Mohammed AI who was seen harassing a woman. And then the question was, when it comes to liability, who bears liability for what a robot does? Is it the manufacturer, the software developer, or the user? So these are the things to think about. And also we should look at the advantages and disadvantages of using artificial intelligence. When it comes to the legal profession, law firms could make use of Law Pavilion. There is this website called Do Not Pay. All you have to do is log in, type in your legal concern, and it is going to give you answers. But then, as it stands now, when you carry your phone and type Meta AI and ask a legal question, Meta will most likely tell you to go back to a legal practitioner. So you see, in as much as AI has come to make life easier for us, as legal practitioners, there is always a need to regulate it so that it doesn't become a threat to humanity. Thank you.
We wish to thank our senior colleague for those beautiful words of admonitions and those contributions. Please let us give her a very loud round of applause. Now we would want to get the observations and the feelings of all of us. And we would want people from the different constituencies to please come out and share their own observations, how you have been touched by the presentations, what you would want to contribute, and however you feel, whatever you feel, we would want to hear from all of us. And we would wish to begin from the ab initio class. We invite that someone from the ab initio class comes up the stage and shares his or her feelings about today's event with us. It is going to encourage us to, we spent just like 3 days to make all these presentations. And many people in the law school class never had a very good night's rest. And they have been able to put up all these things, and we have been thrilled. We have enjoyed all the presentations. Please let us hear from all of us. Someone from the ab initio class, please. We have very limited time, so please. If we do not have someone from the ab initio class, we invite someone from the sophomore class. Someone from the year 2 class. Do not tell us that everything we have done here has been a waste. We know it has not been a waste. Anyone from the year 3 class? Anyone from the penultimate class? All right, thank you very much. We appreciate the fact that you have come out here to at least watch our presentations. If everything that was done here was done without you, then it would have seemed like everything we have done has been a waste. But like we all know, the greatest misdoing that you can give to a presentation is not to appreciate it. The greatest misdoing you could do to a presentation is not to ask questions, not to share your feelings. But we are not, we are thrilled and we are happy that today has been very, very successful. And all our efforts, all our sacrifices have not been in vain. Thank you very much, everybody. Now we call on the judges to give their verdict. The judges, please.
The Dean, Faculty of Law, the Spirit of the Law, a woman who has taught many of us, but is still looking very beautiful. Today they gave you a new husband. Your name has changed from Professor Mojishola is saying to Hanson. I am just wondering which of the Hansons. My lords, thank you so much, all of us on the panel of judges. Can we clap for the year 5 students again? Seriously, it is unbelievable that they have been able to come up with this in 3 days. Year 1 students, let me prophesy. Year 5 students, let me prophesy. For as many of you that want first class in law school, you will have it in Jesus' name. You've made us proud, seriously. You've made us proud. And for the first students, please, may the Lord bless you. Yeah, I know you're starting exams next week, so it's not on Monday. So for you to still be seated here, may the Lord give you success in your exams. The year 3 students, God bless you. Year 2, God bless you. And year 1, may the Lord complete what he has started in your lives. We want to tell all the groups, you did marvelously well. Clap for yourselves. It's not easy being a judge in this competition. I think we've been judges since it started, right? It's not easy. I mean, and it keeps getting better. It keeps getting better. So whether you are the 8th position or you are the 1st, know that you've impacted the world. But I just want to say that we were grading independently, and we've been able to arrive at this result. And 3rd, 2nd, and 1st, even though we were grading independently, we had a synchronization when we were adding up the aggregates of the marks. So without taking so much of your time, I always tell my class, whether you are the first from the bottom, a lawyer must be courageous and proud of who you are. So if you are in the first from bottom, when we call your group, stand up with all gallantry and take a bow. It's not easy to be a year 5 law student. Stand up with STEEZE and composure. All right, the 8th position has 402 marks. And that goes to the aggressors. Can we clap for them? Stand up and take a bow. Can we clap for the aggressors? You really tried. I don't know how you all came up with all those questions for every group. 7th position goes to the Realist School of Law. 404 marks. Realist School of Law, can you stand up and say, be proud, be proud. It's not every case you'll win, I mean. We are taught in law, when you win a case, you celebrate. When you lose a case, you celebrate. And I mean, you can appeal. But in this one, there is no court of appeal. But seriously, we celebrate you too. And I want to say that the scores are very close, extremely close, except for the first position, where there is a large gap. Yes, there's a large gap. There's a large gap. Really wide gap of more than 30 marks. Yes. Meanwhile, in between the others, you're having 2 marks, 3 marks, 4 marks, 5 marks. So the 6th position has 409. Natural Law School. Can you rise up? Natural Law School, rise up and take a bow. Be proud of who you are. The 5th position is 421. Marxism. Can you rise up? Rise up. See my niece. That somebody asked me if you were wearing. Okay. Somebody asked me that. The 4th position is 422. That's just 1 mark difference. Pure theory. Rise up and take a bow. Wait a minute. I want to understand. Year 5, you know I know you people. Who are the ones screaming? Is it pure theory or the people I have not mentioned? I think it's more of the ones that we've not mentioned. You know, I know you people. I've taught it in international law. Peer theory, congratulations, you took 4th position. Judges, we are wondering who took 1st, 2nd, 3rd, right? Who is going to win this competition? Who is going to win? The 3rd position is 433. Positivism! And we have 2 schools left. Sociological and historical. Are we going back to history? Or are we becoming social engineers? The 2nd position is 436. And the 1st position is 471. That's the gap, yes, that's the gap. And the 1st position, I know. The 1st position goes to the judges. 2nd position, 436, Sociological School. Sociological School. At this point, if you don't keep quiet, we can do what was done in 1993. A lot of you were not born. The 1st position with 471 marks. As against 436 marks, is the Historical School of Thought. So, Mayor, can we clap for them? Can I invite all the members of the historical school? You will start with Professor Mojishola is saying, please dress well. Dress well. I don't know why some of you are not happy. I saw some other people hugging them. I saw people from other groups hugging them. They were hugging them, and it's a competition. You win or you lose. I'm not sure everybody there is historical school. Seriously, amen. You are not in historical school. Okay, can you just turn around like this? Turn around like this. Start with Barrister Sidibe. Shake us, judges, please. May we rise, please? Just shake the professor. Shake the professor. Really good. Congratulations. Congratulations. Oh my God, you. I didn't know you could dance so well. Congratulations. Congratulations. The dancers. Congratulations. Oh, you were just something else. You were something else. Congratulations. Congratulations.
Amen. You are not in this group. Amen. You are not in this group. Second position, come and shake our hands. Second position. Sociological school, come and shake their hands. Sociological. Okay. At this point, please, my lords, thank you very much for serving on this panel, and thank you, sir. The Dean of Law, thank you, ma'am. Loss and ginger. Loss and ginger. Please, can I have your attention? Can I have your attention, please? I want to say that all of you are my own winners, because I'm shocked for you to be able to put this thing up. The spirit is moving. The spirit is shaking. Pay attention. And thus says the Spirit of the Lord. Thus says the Spirit of the Lord. This one prophecy must come openly. Thus says the Spirit of the Lord. Spirit Ododi. Discuss. 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 Any theory of law of your choice, stating the tenets and criticizing the school, says the Spirit of the Lord. Thank you so much. Honestly, I'm sure there's no school by after conversion that wouldn't make more than 13.5 or 14 over 17.5 for question 1. And of course, for your CA, you should have nothing less than 11 or 12 over 15. So you've all done very well. We appreciate you. Now we need to leave this place fast. There won't be party after party this year. I'm sorry. As soon as, in fact, I will not leave this all until all of you leave to your father's houses and mother's houses. I'm not leaving you here. No, excuse me, listen. We need to maintain some STEEZE. Because, listen, because of some security composure. So please, we need to go. Thank you so much. But before then, let me call on the chairman of the planning committee, Idorenya Pabio. Where is he? To just give a vote of thanks to the judges and others. They've all tried. These children spent money. I gave just a token, but I'm sure because this thing is done with money. It's not faculty money. They went on their own. Even the feeding, I'm shocked though. This one, nothing. So they've really done well.